322, the only thing that's remaining in that is the one document, 322.001. Where's the business card? So it's now broken into three exhibits, 322.001 and 322.002. So we've separated it out. We can put the business card aside for the time being.
Thank you, Your Honor.
Proceed.
Thank you, Your Honor. Mr. had reviewed the document that Stan Cook prepared. Did you take any other steps for him to deliver that document? Well, let me ask you this. At some point, were you asked to draft a letter to
question asked whether or not you drafted a letter, not what advice you gave, whether you drafted a letter, yes or no?
Did you draft a letter from Mr. Cook to a news agency?
Yes.
What was the purpose of drafting that letter?
He wanted
Objection,
some,
hearsay.
Sustained. Counsel, go to the next question.
Yeah, sure.
The letter either speaks for itself or it doesn't. We don't need him to interpret it.
So you wrote this letter. Did you send it off?
no,
Who did you give it to?
Stan,
Did you transport Mr. Cook anywhere after having drafted that letter to the news agency?
weeks later,
Did you contact anybody?
no,
Did you contact any news agencies?
no,
They said weeks later. Let's start. When was the letter that he showed you, or when did he show you the letter and you print it out and go through the draft?
it was, I believe, 3 or 4 days before the attack on Marissa.
So it was in early February.
Yes, I believe so.
Now you said weeks later you were asked to take him somewhere.
Correct.
Who asked you?
Stan asked me to take him.
And where did he ask to be
Hearsay,
taken?
objection, hearsay.
The objection's overruled. It's preparatory to the next question. Counsel, please be more articulate in your questions. And you know how to avoid hearsay. Please ask the questions of what he did, what he said, and those type of things. But if it's going to call for that kind of stuff, please avoid it.
Yes, sure. Where did you take Mr. Cook?
To the Tempe Police Department.
You actually drove him?
Yes, I did.
Other than you and Mr. Cook, did anybody else come with you?
No,
Did you go inside the Tempe Police Department with Mr. Cook?
yes, I did.
Did you meet with any police officers at the Tempe Police Department?
I did not.
At some point later that same day, did you drive Mr. Cook from the Tempe Police Department?
Yes, I did.
Where did you go?
To the Gilbert Police Department.
Were there any news media there?
No.
When you went to the Gilbert Police Department, did you meet with any police officers on that day?
No.
Was it still just you and Mr. Cook at that time?
I had to pick up my son, Andrew, who was finished with school.
So it was you, your son David,
Correct.
and Mr. Cook who went to the Gilbert Police Department.
Correct.
And did you drive Mr. Cook away from the Gilbert Police Department?
I dropped him off and went home and returned later to pick him up.
And when you picked him up after going to the Gilbert Police Department, where did you go?
To my house.
Upon getting to your house, were you contacted by the Gilbert Police Department?
Yes, they were there.
Was that the same day that the first warrant on your house was served?
Yes, they were.
Mr. Flores, you exchanged several text messages with the defendant from February 18th to February 19th. Is that correct?
Yes.
Sir, I'm handing you what's been marked as exhibit number 428. Can you take a moment to look at those?
Yes.
Are those photographs of the text messages, or at least some of the text messages that you exchanged with the defendant during that time period?
Yes, I believe so.
Your Honor, move to admit exhibit number 428.
Objection.
Basis
Foundation and relevance.
overruled on both grounds.
Mr. Flores, what I'm going to ask you to do is, as we go through, since we don't have the Elmo set up, what I'm going to ask you to do is go through the text messages in the order that they are. I want you to tell the jurors who the text message is from and who it is to as you read it, so that they understand the context of the text message.
To begin,
Yes.
dated February 18th, 10:30. This is need to talk to Goober. He is all pissed about something, and I am done kissing his ass. I would rather die than kiss his retarded ass.
Who is she referring to when she mentions Goober?
Stan.
Do you know what the context of that message is? Talk to him about what?
Counsel, he can read her email, and he can indicate, as he just did, who Goober was. The email stands for not an expert in her mind, and it's off bounds, so please stay away from it.
Your Honor, can I ask if he had asked a question of her about what that meant?
Did he send an email? Did he send a text message? Or
Did you talk to her about what that text message was about?
Same objection, Judge.
first of all, if you talk to her, please lay a foundation when, either before, during, or afterwards. If it's afterwards, again, if what you want in is her text messages, and either bring in an expert, but I'm going to find that he is in no better position than the jury to determine the intent of the parties here in this case. So read the text messages in, and that's the only context there is, that's fine.
Did you ever have a conversation with her after that message was sent to determine its content?
I did not.
Okay. Can you read the next text message, please?
Lots of country possibilities, but if no stand, we won't be discussing it for 15 to 20 years.
Now, that's a text message that you sent to her.
Correct.
Now, what did you mean when you're talking about Stan?
Stan was going to turn himself in, and if it was true that Stan had indeed done the attack, then she had discussed us moving someplace out of the country.
And you had her passport and the children's passport at your house.
Correct.
Can you read the next text message, please? And who it was from?
From her. Thought you would be busy, not getting much work done, hoping I get better so I can drive myself off a cliff. LOL.
Can you read the next text message, please?
From me to her. I'm working a bit, but not sleeping. Haven't you noticed how exhausted I am?
And can you read the next text message?
From her to me. Yeah, was hoping my Cliff Drive would fix that too.
At that point in time, were you spending a lot of time with her?
Yes, I was at the hospital every day.
Can you read the next text message, please?
This was from me to her, but I still come to be by your bedside as much as possible.
Objection, Your Honor. May we approach?
Sidney, would you please take the jury out?
Please rise for the jury.
Please be seated. Can I see the text message, please? Your objection, counsel?
Your Honor, the facts and circumstances surrounding Ms. DeBraw's hospitalization were addressed in a 404B motion that was ruled upon, I believe, if I'm not mistaken, by Judge Brnovich. And Judge Brnovich ruled at the time that those facts and circumstances were not admissible and wouldn't be coming in unless the defense in some way opened the door to that topic. I believe this line of questioning with references to her being hospitalized is going into those matters sort of in a backhanded fashion.
Well, up to this one, and even this one, I'm not so sure, other than what you now told me, that says much more, and that's why I want to stay away from the interpretation. All it says is, but I still come to be by your bedside as much as possible. What does that mean? Come over to your house? Seems innocuous enough. It doesn't seem to be talking about it.
I'm just concerned about where this may go, and Mr. Flores has already mentioned the attack on our client. And again, I just think we're getting awfully close to that line.
Where was it mentioned, the attack on your client?
Mr. Flores mentioned it just a few moments ago in his testimony, Judge, in the context of placing something in history.
Well, there's two duplicates in the stack, but there's nothing else in here other than so your objection is sustained and is overruled for the purposes of this one. Doesn't refer to her being in a hospital. This is by your bedside, and in the context of all these other messages, I think it becomes clear to the jury where the state wants to go. But again, I'm not allowing Mr. Flores to interpret the text messages. The text messages are statements of your client. They're not hearsay by definition, and therefore they're going to come in.
And Your Honor, just to let you know, Mr. Flores has been advised not to mention the specifics about the attack on the defendant that occurred on February 9th. So he has been advised of it.
Well, you think he's wandering into the area in motions eliminate, counsel? I had that out with everybody before we took the break. We have your motion eliminate, and if you folks want to play the game, then go ahead. Because again, once the motion under Palinkas is made, once it's granted, and if someone steps over the line, it's preserved for appeal purposes without further objection. And in Palinkas, it was reversed because of the motion to eliminate without objection. And despite the state's very, very strenuous argument that it was waived, it was invited error, and all the other necessities, one way or the other. But we'll go. Let's get moving again. wants it. Two, the only one not broke 22.
Viewed that document.
One question is whether or not you drafted a letter, not what advice you gave, whether you drafted a letter, yes or no.
Did you draft a letter from Mr. Cook to a news agency?
Yes.
What was the purpose of drafting that letter?
He wanted
Objection,
some,
hearsay.
Sustained. Counsel, go to the next question.
Yeah, sure.
The letter speaks for.
Contacting the news. When was asked you?
The next question. Articulate questions of what he's avoided.
You actually.
I did not.
Did you drive, Mr. Were there any news with any police
My
officers?
son,
The Gilbert Police.
I dropped him.
Upon getting to your first warrant on exchange, sir, I'm handing you. Some of the text
Yes,
messages.
I believe so.
28. They almost set up. And who would?
Stated, I would rather stand.
Messages.
No. Not an ex. Or
The next
Of us,
text.
is in.
Never have a conversation
and I did not. Lots of
you
countries
sent,
stand and had
and you had, please.
busy, not
Can you message?
to.
Objection, counsel.
Your Honor, the facts and circumstances surrounding Ms. Devault's hospitalization were addressed in a 404B motion that was ruled upon, I believe, if I'm not mistaken, by Judge Brnovich. And Judge Brnovich ruled at the time that those facts and circumstances were not admissible and wouldn't be coming in unless the defense in some way opened the door to that topic. I believe this line of questioning with references to her being hospitalized is going into those matters sort of in a backhanded fashion.
Well, up to this one, and even this one, I'm not so sure, other than what you now told me, that says much more, and that's why I want to stay away from the interpretation. All it says is, but I still come to be by your bedside as much as possible. What does that mean? Come over to your house? Seems innocuous enough. It doesn't seem to be talking about it.
I'm just concerned about where this may go, and Mr. Flores has already mentioned the attack on our client. And again, I just think we're getting awfully close to that line.
Where was it mentioned, the attack on your client?
Mr. Flores mentioned it just a few moments ago in his testimony, Judge, in the context of placing something in history.
Well, there's two duplicates in the stack, but there's nothing else in here other than so your objection is sustained and is overruled for the purposes of this one. Doesn't refer to her being in a hospital, this is by your bedside. And in the context of all these other messages, I think it becomes clear to the jury where the state wants to go. But again, I'm not allowing Mr. Flores to interpret the text messages. The text messages are statements of your client. They're not hearsay by definition, and therefore they're going to come in.
And Your Honor, just to let you know, Mr. Flores has been advised not to mention the specifics about the attack on the defendant that occurred on February 9th. So he has been advised of it.
Well, you think he's wandering into the area in motions and eliminate counsel? I had that out with everybody before we took the break. We have your motion and eliminate, and if you folks want to play the game, then go ahead. Because again, once the motion under Palinkas is made, once it's granted, and if someone steps over the line, it's preserved for appeal purposes without further objection. And in Palinkas, it was reversed because of the motion to eliminate without objection. And despite the state's very, very strenuous argument that it was waived, it was invited error, and all the other necessities, one way or the other. But we'll go, let's get moving again.
Please rise for the jury. Please be seated.
Counsel, in the stack that they're coming up, there are two duplicate text messages, so you don't need to go through both of them
Yes,
each
sir.
time.
Mr. Flores, if you wouldn't mind reading the next text message.
The next one was from her to me, seems like a waste.
And could you please read the next one?
Only if Stan is an asterisk.
And who sent that text message?
I did.
What did you mean when you wrote only if Stan is an S? Or an A, asterisk, asterisk?
If Stan was not going to step up and admit that he was the person who had committed the attack.
I assume that the asterisks were S and S?
Yes.
Okay. If you could read the next text message, please.
There's a typo. I love ought and you, but it seems like a big waste because I know and you know Stan is going to back alley and I am not going to be here.
And the other part's I guess the duplicate language of that previous text message? Or is it?
That's one not a duplicate.
Okay. If you could read the next text message, please.
From me to her, that it won't be for lack of love or trying on my part.
And the next text message, please.
Was from her. and you don't see where he is. I told you he had one request, and I did teaching him along the way, and now he got me into bed without paying the price. Gay men suck.
Did you ask her who she was talking about when she was referring to a gay man?
No.
Okay.
That was clear.
If you can,
It does continue.
okay.
That's what I was looking at. It appears that it's multi-part. Without paying the price, gay men suck. Doesn't matter, I sold me soul. I am nothing anymore, and I know it. I went against my mind and my heart to be with him, and I killed myself to do it.
Mr. Flores, during the week that we've had off, I had asked that you review your March 16th, 2009 interview with the police regarding your conversation regarding a life insurance for Tristan. Is that correct?
Correct.
When you had testified before, you had testified that you did not remember the defendant saying that the life insurance policy wasn't on her father-in-law after you discovered he was alive, but in fact the life insurance was on a child of hers named Tristan. Is that correct?
Correct. Can I explain why?
You know, so let me, just to make sure we've got it right. After you had found out that Michael Wright was alive,
Correct.
she had explained to you that the life insurance was actually on Tristan.
Correct.
So you still believed at that point that there was a life insurance policy, it just wasn't on Michael Wright.
Correct.
And you continued to loan her money on that point.
Correct.
You don't have no further questions at this time.
Cross-examination.
Thank you, Judge.
Good afternoon, Mr. Flores. Mr. Flores, for the most part, I'm going to ask you some questions that are going to call for yes or no answers. Are you clear about that?
Yes.
Counsel, he can answer your questions to the best of his abilities. If you don't believe they're responsive, then you ask me to strike the answer as not responsive. You're not entitled to any specific answer. You can ask a question, he can respond, and if it's not responsive, I will deal with it. Do you understand that, Mr. Flores?
Yes, sir.
Proceed.
Now, Mr. Flores, myself and Mr. Cavasoli interviewed you back on June 15, 2010. Do you recall that?
Yes, I do.
Also, I recently conducted a deposition on you back on January 29th of 2014, of this year. Do you recall that?
I do.
And that proceeding was conducted under oath, correct?
Correct.
Now, Mr. Flores, you're quite a bit older than Ms. Devault, are you not?
Yes.
How old are you?
I'm now 56.
And do you know her age?
I believe she's 35 now.
You grew up in New York,
Correct.
Brooklyn.
Yes.
You went to college,
Yes.
attended Yale University.
Yes.
You have an MBA also from Yale.
Correct.
At some point in time, you received a doctorate
Correct.
from a university in England.
Correct.
For a while, you taught at Yale.
Correct.
And your testimony on direct was that you're a self-employed management consultant.
Correct.
specializing in supply chain optimization.
Correct.
Now, you had an interview with the Gilbert Police Department on or about February 20th of 2009. Do you recall that, the first meeting with the Gilbert PD?
I believe so, yes.
Okay. And do you recall during that interview saying something like, and this is a verbatim, computers are my business runs on computers?
Yes.
Okay. Would you consider yourself a sophisticated business person?
Reasonably.
Okay, you're no sucker.
When it comes to business, probably not.
Now, Mr. Flores, you're represented by counsel.
Yes.
Could you point out for the jury who your attorney is and where he's seated?
Yes, for Quarles and Brady.
Okay. And how long has Mr. Diaz represented you?
For almost 5 years now.
Since very close to the beginning of these proceedings.
Yes.
Okay. And at our interview in 2010, you actually also flew in an attorney from London, England, didn't you?
Yes.
And that person brought with her a couple of assistants.
Correct.
And you paid for them to come to the United States and be present at that interview, correct?
They offered to come as part of my counseling.
But that wasn't an offer that was a free offer. You paid for them to come here.
Yes.
Okay. Now, you mentioned that Mr. Diaz works for the Quarles and Brady firm.
Correct.
They're a reputable, qualified law firm here in Phoenix.
Yes.
And you mentioned that he has been your attorney throughout these proceedings. He has appeared in this case on your behalf.
Yes.
And at one point, he even filed a special action with the Arizona Court of Appeals in this case on your behalf, correct?
Correct.
However, the first time you spoke to the Glendale Police Department on February 20th of 2009, you were not represented by Mr. Diaz at that particular hearing, or at that particular interview, I should say. The first one.
Correct. You said Glendale. I assume you meant Gilbert.
Oh, I'm sorry. I didn't mean Gilbert. I apologize. I misspoke.
That first one, I was not represented by you.
Okay. And after that interview, which lasted just under 2 hours, the Gilbert Police Department apparently must have still had a few questions of you, correct?
Apparently.
Because they sort of invited you back for another interview, didn't they? And that interview occurred on or about March 16th of 2009?
I believe so.
And Mr. Diaz was present at that interview.
Correct.
And then, even after that interview, they sort of invited you back again, did they not, for a third interview?
Yes.
And that interview was a rather lengthy interview, wasn't it?
Yes, it was.
Pretty much all day. Would you agree?
It was quite lengthy.
And again, Mr. Diaz was present for that, correct?
Yes.
Now, at some point, through your attorneys, did you notify the court and the parties in this case that you were going to decline or refuse to testify?
Yes.
Your Honor, relevance.
Overruled.
And that you wouldn't be testifying unless you were granted immunity, correct?
Correct.
State and federal immunity, correct?
Correct.
And through your counsel, you raised certain concerns about your testimony,
Correct.
that you could be implicated in crimes.
Yes, in response to the motion that you had made, yes, that's correct.
And among the crimes that you expressed concern about through your attorneys being implicated in included being an accessory or an accomplice to murder.
Correct.
You were also concerned about obstruction of justice and hindering prosecution charges potentially.
Correct.
And there was another charge that you were concerned about that we'll get to later, that you expressed some concerns about, correct?
Correct.
And the immunity that you asked for was both state and federal in scope, correct?
Correct.
And you received certain assurances from the county attorney's office, correct?
I don't know what you mean by
Okay, well, let me rephrase that. That was a inarticulate question. You did in fact receive immunity from the county attorney's office concerning your testimony in this case.
Correct.
And you were also shown a letter from the United States attorney, correct?
Correct.
That indicated that you would have federal immunity as well.
Correct.
And the immunity agreement that you have with the state provides that your statements given in this court case cannot be used against you in any prosecution for any of the possible crimes I mentioned before.
Correct.
Accomplice to murder, hindering prosecution, etc. And you would not have testified in this case had you not been granted state and federal immunity, correct?
Correct.
Mr. Flores, I'm going to show you what has previously been marked as Exhibit 432. Could you review that, please? Let me know when you're done reviewing it. Do you recognize that document?
Yes, I do.
What is it?
It's the 6-page motion to the court entitled Notice of Intent to Invoke Fifth Amendment.
And that was prepared by Mr. Diaz
And his firm, yes.
on your behalf.
Correct.
Your Honor, move to admit Exhibit 432.
Object, Your Honor, hearsay.
Overruled. I'm overruling it not because under State versus Swinburne it's relevant, therefore it's coming in.
Your Honor, permission to approach Mr. Flores.
Sure.
Now, Mr. Flores, I'm going to now show you two documents which are marked as Exhibits 430 and 431. Could you take a moment to review those?
Yes.
Starting with 430, what is that document?
Do you want me to just read the title?
What's it entitled?
State's petition for order granting immunity to witness and order.
Does that document indicate who prepared it? You may want to look in the upper left-hand corner of the document.
Yes, this was from the county attorney's office,
And specifically who?
Mr. Boston.
Okay. Move to admit Exhibit 430, Your Honor.
No objection, Your Honor.
It's received. The court will take judicial notice of its own court orders.
Thank you, Judge. And likewise, 431, what is that document entitled?
It's just entitled Order.
And what does it go on to say?
It says, it's hereby ordered that Alan Forrest, the witness above named, is hereby required to give testimony or produce evidence as to the within matter.
Okay. And again, that was prepared by Mr. Basta.
Correct.
Move to admit 4031, Judge.
Can the court takes judicial notice of its own orders and pleadings in this matter?
Okay. Now again, Mr. Flores, we spoke back on January 29th of this year at your deposition, did we not?
Yes.
And one of the topics we talked about at that deposition was the fact that when the Gilbert Police Department seized and analyzed your computer, a substantial amount of child pornography was found on your computer, correct?
That's
Your
right.
Honor, argumentative.
Overruled.
That's what I was told.
Okay. And you, of course, discussed those matters with your attorney, Mr. Diaz.
I believe that's attorney-client privilege.
Okay.
Okay, let's hold it. Sydney, take the jury.
Please rise for the jury.
Be seated. Now, in pretrial rulings, it was my order, state would be allowed to, or the defense would be allowed to ask whether or not Gilbert seized the computer, whether or not the computer contained images that were in fact child pornography, whether or not he was given immunity from prosecution for anything found on the computer, and if the answers to those questions were yes, other than talk about the fact that he was facing natural life in prison, that was the end of the inquiry. So, rather than follow the script, rather than do what I ask everybody to do, counsel decides to wander on and start asking about whether or not he discussed it with his client or with his lawyer. State versus Swinburne is so basic, so straightforward. I don't understand why we're even in this situation. You can ask whether or not he was subject to prosecution for the items asked on the computer and whether he's facing life imprisonment, but that's where it ends. Don't get into conversations he had with his lawyer. Stick to the script that I gave you when we began with. You have the argument. It shows his motive to lie, his reason to cater to the state. All of that's argument. And Mr. Flores, you have an obligation to testify. I told you that, I told you that, I told you that. You have an immunity agreement. So they can get into certain things one way or the other, and it's not for you to enter the objection, it's for the state of Arizona. Do you understand? Now, if you want me to reverse my ruling, if you want me to preclude you from going into this whole side detour into what the evidence is, fine, I'll do it. But either stick to the script I gave you or don't. That's your prerogative. But I'm not going to allow this decision to freelance and start stepping on the corners of it to gain whatever advantage or argumentative nature of it. One way or the other. It's relevant only to show his interest, and after that, it ends. Am I clear?
You are, Judge.
Bring him in. I don't know anyone with that. So, they haven't been moved in. Hold up. Here it is.
Please rise for the jury.
That's a judicial notice. Well, yeah, that means they're. question's stricken, you can rephrase the question.
Thank you, Your Honor. I'll just move on.
No, rephrase the question the way I indicated.
Mr. Flores, you are aware of the fact that if you were convicted of possessing the pornographic images on your computer, the child pornography, you'd be facing a life sentence.
I was informed of the penalties.
Now, the letter that purports to be Stanley Cook's confession letter, that was also found on your computer, correct? When the Gilbert Police Department analyzed your computer.
I don't know.
Do you dispute the fact that it was in fact on your computer?
I don't dispute that it may have been.
Okay. And you claimed on direct that you were shown that document on screen and that you told Marissa and Stan something like, I can't have anything to do with this. You recall that?
Yes.
But you actually did have something to do with it, didn't you?
Yes, they pressed me and I did make some edits.
And you stated on direct that you read documents better in hard copy format, correct?
Correct.
So you imported the document onto your computer so that you could print it out in order that you could read it more carefully, correct?
Correct.
And you indicated that it was imported to your computer via some kind of thumb drive or data stick, correct?
Correct.
Your thumb drive.
That I had given them. Yes.
And you testified that you reluctantly reviewed the letter,
Correct.
which several versions of which is contained in Exhibit 322, correct? You looked at that earlier.
Yes.
And the documents in Exhibit 322 contained handwritten notes that you wrote upon those documents, correct?
Correct.
So apparently you reluctantly also edited the letter.
That's what I said, yes. I made some suggested changes on the paper.
Okay. And you actually drove Stan to the police department to present that letter, correct?
I don't know if the letter had changed in the figure being a couple of weeks. But yes, I did drive Dan to the police department.
And you knew what he intended to do at the police department.
Yes.
And you waited around until he came back out, correct?
At the Tempe Police Department, yes.
And you later drove Stan to the Gilbert Police Department, correct?
Correct.
And when he was done speaking with the police at the Gilbert Police Department, you drove him home.
Correct.
And at some point later picked him up again and brought him back to your house.
Not that evening, no.
Okay. In any event, that same day the police showed up at your house, correct?
Correct.
With a warrant.
Correct.
Now, your first interview with the Gilbert Police Department on the 20th of February of 2009, that occurred at night,
Yes.
and that ran about 2 hours.
Yes, sir.
And at that time, you told the Gilbert Police Department that Marissa worked for you, correct?
Correct.
You never mentioned anything about any debt at that time that she might have owed you.
No.
You never mentioned at that meeting anything about a promissory note. You never mentioned at that meeting anything about insurance policies.
I was never asked any of those things, no.
You never mentioned anything about any kind of trusts at that meeting.
No.
And you certainly never mentioned anything about conversations concerning any alleged plot to kill Mr. Harrell at that meeting. However, toward the end of that first interview, you did in fact tell the Gilbert Police Department that I'm trying to tell you everything. That's exactly what you said, right?
Yes.
But you really did not tell them everything at that time, did you?
They were asking me about a specific,
Objection, Your Honor, not responsive.
Sustained. Please answer the question, sir.
You didn't tell them everything at that time.
no,
And towards the end of the interview, you talked with the police about how you and Ms. Devault met.
yes,
But what you told police at that time wasn't entirely true.
correct.
You mentioned something to the police about having met at a pizza place and later at a Bash's, right? That was your story at that time?
Correct.
But in fact, you actually met through an online website, correct?
Correct.
And the online website that you met through was something like seekingarrangement.com, correct?
Correct.
Is that a website that facilitates people getting together for the purpose of having sex?
For having a relationship with an arrangement.
Okay. And you claim that after seeing Ms. Devault at the pizza place, you just coincidentally stumbled across her profile on seekingarrangement.com, correct?
Yes, that is correct.
Okay. Now, let's sort of cut to the chase. You and Ms. Devault were having sex. You were in a sexual relationship, correct?
From our first date, yes.
From your first date. Okay. So you began having sex the first day you met
Correct.
and continued having sex regularly until Ms. Devault was taken into custody the second time, correct?
Correct, that 2-year period.
Okay. But at the first interview with the Gilbert Police Department, you indicated to them that you and Ms. Devault had only dated casually, correct?
Correct.
And you stated to them that you had been sexual, to use your term, at only a couple of points, correct?
I don't recall that, but that's possible.
Do you dispute that that's what you said?
No, I don't.
And that, of course, is not true.
Correct.
You and Ms. Devault often got together late at night, didn't you?
No, usually not late at night.
Never?
Rarely, because she had her kids, I had mine.
Okay.
Most of our meetings were during the day.
Okay, but again, okay, sometimes you did get together during the day, correct?
Yes,
You even took some trips together,
correct.
including one to Vegas,
2,
two to Vegas, okay, very well, and a trip to Florida
correct.
with all of your kids, yours and hers, correct?
Correct.
And you purchased all those airline tickets for the Florida trip,
Correct.
and everyone stayed at your timeshare condo.
2 condos, yes.
Okay, all right. Now, during your direct testimony, you went through a series of promissory notes. You recall that?
Correct.
And some supporting spreadsheets
Yes.
that related to those promissory notes, correct?
Correct.
And those spreadsheets were a detailed listing or inventory of all the money you had advanced to Ms. Devault.
As part of the loan.
And in fact, they were a very detailed inventory.
That's the only way I know to keep records. Yes.
And it even contained entries for things like a gallon of milk at the convenience store.
Yes.
Now, when you're advancing Ms. Devault money, you were aware of the fact that Marissa had a very poor credit history, correct?
Correct.
But you didn't demand any kind of collateral to secure the loan?
I believe she had insurance proceeds.
Objection, Your Honor, not responsive.
Sustained. Answer the question.
You didn't demand any kind of collateral.
No, I did not.
Wouldn't a sophisticated business person typically require some kind of real verifiable collateral to secure a substantial personal loan when dealing with someone with bad credit?
For an arm's length transaction, yes.
Okay. You mentioned on direct that you were notified by Ms. Devault about the existence of some purported trust funds or insurance proceeds, correct?
Correct.
But you really never took any meaningful effort to verify their existence.
I tried.
And you didn't verify it.
No.
You never saw a trust document.
No.
You never saw an insurance policy.
No.
Now, you mentioned on direct that you're a meticulous record keeper, correct?
Yes.
You never asked Ms. Devault for any kind of receipts or documentation?
Often.
Okay. But didn't get it, generally.
Occasionally I got some.
For the most part, did not.
Correct.
At one point in your direct testimony, you testified that you advanced Marissa $15,000, but that you now don't even recall why. You remember saying that?
I do.
And another time, $17,500, right?
Correct.
And at one point, you even paid for her children, and Mr. Harrell to go on a trip to Georgia, correct?
I advanced the money, yes.
And did you buy the tickets in that case also?
Yes, I did.
So you were aware that Mr. Harrell was going on that trip because you bought his ticket.
Correct.
Now, in the first 5 weeks that you knew Ms. Devault, you advanced her something like $4,528. Does that sound right? In the first 5 weeks.
Probably, yes.
Okay. And you were having sex all along during the first 5 weeks.
Yes.
Okay. And in the first 3 months, you gave her somewhere in the neighborhood of $27,557, correct? No concerns?
I had some concerns, but none that were too great.
Okay. And of course, you stated you didn't have any collateral and you didn't verify the existence of any of these purported incoming funds.
I believe so.
But you still continue to have sex regularly.
Yes.
And over the course of 6 months, your testimony was that you, at that point, had given her approximately $62,000 in 6 months.
Yes.
And ultimately, your testimony was that Marissa's debt was $362,000 in less than 2 years.
Correct.
And all the while, you're regularly having sex.
Yes.
And during those 2 years, you stated that you caught Marissa in a number of lies.
Yes.
Some of them were concerning these alleged trust funds and insurance proceeds, correct?
Correct.
For example, you learned that her father, who you claim you had been told was dead, wasn't really dead.
Correct.
For another, you mentioned that you were paying Marissa's rent in 2006, correct?
I was loaning her the money to pay the rent, yes.
And that rent was something like a little over $3,200 a month, correct?
Correct.
And your statement on direct was that she was paying in rent for far more than the value of the rental property because you claim you were told she went through a bankruptcy with her ex and was not receiving any kind of child support, correct?
Correct.
Now, court orders concerning bankruptcies and child support orders, they're public records. Those are obtainable online, correct?
I don't know.
Okay. These were things you could have investigated.
I could have.
The types of things a prudent business person might try to check out.
Yes.
You even testified on direct that at one point, Ms. Devault wrote you a check that was returned for insufficient funds. So she actually bounced a check to you. And you're still advancing her funds.
Correct.
And you're still having sex.
Correct.
And at some point you stated that you had some meeting with the bank manager who seemed to indicate or suggest that Ms. Devault's bank account for some reason couldn't accept direct deposits.
She was guessing why, and
Objection, Your Honor, not responsive.
Sustained. Answer stricken. Question is did you have a meeting with the bank manager, yes or no?
yes, we met with the bank manager.
Okay.
And
Next question.
Your statement on direct was that that person told you that her bank account couldn't accept direct deposits.
She thought the account could not accept direct deposits.
Okay. Did that sound right to you, that a bank account couldn't accept deposits coming in?
Yes, there are some restricted accounts for
Okay.
people in bad circumstances that cannot accept incoming.
Okay. You testified on direct that she stood you up in court one day
Yes,
and that she came up with some odd excuse.
yes,
You testified on direct that at one point she was supposedly at the Santan Mall doing some kind of charity gift wrapping event.
correct,
And you went there
correct,
and confirmed that she was in fact not there.
correct,
And on direct, you stated that at one point you claimed she was supposed to bring over a box of insurance and trust-related documents,
correct,
but that Dale, her ex, who you understood didn't even live with her, took her truck and discarded the documents.
that's what I was told.
Okay. And that's what you believed?
Yeah,
Okay. And you kept advancing her sizable sums of money,
yes,
even after you learned that Dale was living at her house, at their house, which you were paying for. You kept advancing her money. And you still never verified the existence of these supposedly incoming funds, even after all these lies.
I tried.
But you didn't.
No,
Now, in the last promissory note, there is a purported lien on Ms. Devault's house. Do you recall that?
I added a sentence to that effect, yes.
Yes. You knew she didn't even own the house. You knew that.
No, I knew it was in, I was told it was in dispute.
Okay. You had been paying what you characterized as her rent for many months. That was your term, right?
Not for that house, for the prior house.
Okay. All right. Now, let's talk about the promissory notes. The last promissory note, do you recall what the stated interest rate was on that note?
I believe it was consistent at 2.5% per month.
Okay. And that works out to 30% a year, right?
Correct.
Now, you stated on direct that you actually loaned Ms. Devault a pistol, correct?
Correct.
And you made a note that you did so on January 7, 2009 at 2:30 in the afternoon, right?
Correct.
Do you recall during your first interview with the Gilbert Police Department that you told them that you lent it to her in December 2008?
Yes.
That's what you told Gilbert Police Department at the time, not January 7th.
Correct.
And that December 2008 date is also what you told Mr. Tavasoli and I during your defense interview, right?
I don't recall.
Okay. Do you dispute that?
I don't dispute it.
Okay. Now, during your direct testimony, you testified that at some point you began to fear Ms. Devault.
Correct.
And on direct, you said that at some point you were seriously concerned that she was going to harm you in some way.
Correct.
But you never contacted the police. Yes or no? You never contacted the police.
No, she was arrested the next day.
At no point did you ever ask for your gun back.
It was already in police custody.
Now, when you say she was arrested and you say the gun was in police custody, you're talking about the first time she was taken into custody, correct, Mr. Flores?
Correct.
Okay. And you're afraid of this person, according to your direct testimony, correct? Yes?
I had concerns, yes.
Okay. That's what you stated on direct, is it not?
Correct.
Now, you also dropped off a phone for her to use at the police station, didn't you?